Hello, my name is Marcin Szwed and I'm coordinator of the Strategic Litigation Program at the Helsinki Foundation for Human Rights in Warsaw. And I will speak a few minutes about problems with implementation of judgments of the European Court of Human Rights in Poland. So there are various problems in this area. First of all, there are several judgments of the court which remain unimplemented for many years. So this concern in particular judgments concerning abortion, so cases like Tysiąc versus Poland or P&S versus Poland, and another very important group of cases which concern excessive length of proceedings before Polish courts. So these judgments remain unimplemented for various reasons. So judgments concerning abortion cases, they are unimplemented for, let's say, political reasons. Like there is no political will among Polish political class to implement this judgment. So our current government is more conservative, and they are opposing abortion on moral and ideological grounds. So recently, the situation around access to abortion even worsened in Poland because of the judgment of the Constitutional Tribunal, which even restricted the access to legal abortion by eliminating condition of legality abortion in cases of damages of fetus. And it is very unlikely that these judgments will be implemented in the next years. What is even more, there have been new cases communicated to by the court to the Polish government, which concern strictly situation after the judgment of the Constitutional Tribunal. The situation with excessive length of proceedings cases is slightly different. So here I wouldn't say that there are some political or ideological barriers to implementation of the judgments. The problem is different. Elimination of excessive length of proceedings in Poland would be a very difficult and complicated process. The problem of excessive length of proceedings is very complex and would require very thorough reforms in various areas of law. This is not only a matter of appointment of new judges, but also probably some reforms in procedural law should be adopted. And what is even more, there are some problems, as you probably all know, with rule of law in Poland. Status of many new judges are being questioned, and these doubts around the status have legitimate grounds in the case law of the European Court of Human Rights and the Court of Justice of the European Union. So instead of eliminating the reasons for excessive length of proceedings, the situation will probably even get worse, because there will be a complete chaos and no one would know which judgments are valid and which are not. What is more, in addition to these problems with judgments which remain unimplemented for many years, in the recent months, new threats to the effectiveness of the implementation process appeared. These problems concern, in particular, judgments of the Constitutional Tribunal, which question the constitutionality of European Convention on Human Rights, and several judgments of the European Court of Human Rights. So far, in November 2021, the Constitutional Tribunal issued a judgment concerning Article 6 of the Convention, not whole Article 6, but only in this part, as it formed the ground for the court to issue judgment in ECtHR versus Poland. So this judgment of the court concerned a violation of the right to a tribunal established by law on account of participation in the panel of the Constitutional Tribunal of unlawfully elected judge. And the Constitutional Tribunal ruled that Article 6 of the Convention, insofar as it is applicable to the proceedings before the Constitutional Tribunal, is inconsistent with the Polish Constitution. Another case right now is pending before the court. It concerns Article 6 insofar as it formed the basis for issuing judgments in Broda and Bojara versus Poland, which concerned dismissal of vice president of courts, and Reczkowicz versus Poland, which concerned unlawful appointments to the Supreme court, but so far the judgment has not yet been issued. And this process of questioning of the European Convention on Human Rights and questioning judgments of the European Court is very dangerous, because, as probably everyone can expect, judgments of the Constitutional Tribunal will probably serve the Polish government as an official excuse not to implement judgments of the European Court. So probably these judgments will not be implemented on a general level for next few years, until probably some political changes in Poland happens. We don't know right now whether the government will also refuse to adopt individual measures of implementation. That is, whether the government will refuse to pay compensations awarded to the applicants by the court. We have no such data in the Helsinki Foundation, so it's hard to speculate on this matter. However, we are afraid that this practice of questioning of judgments of the European Court by motions to the Constitutional Tribunal will be applied in future, not only in cases concerning reforms of the judiciary in Poland, but also in some other cases which will not be accepted by the government. So this could, for example, concern judgments concerning LGBT rights. So the situation in Poland regarding implementation of judgments does not look very optimistic, and there are very serious threats which are very dangerous from the perspective of implementation of the European Court of Human Rights judgments. Thank you very much.